Well, I was planning on talking about, I guess, what they call ADR, alternative dispute resolution. So, like Craig mentioned, there's kind of the transactional side of what we do, which is helping people buy. And then probably the majority of stuff that we do revolves around what happens when things don't go the way that one of the parties expected.
So when you say helping people buy, now most people are going to think, well, isn't that what the realtor is for, and maybe the mortgage partner involved in the deal?
Right, and we've talked about this. I mean, one of the challenges with relying, and they're great professionals to have around you, and you need these guys around you. So, but one of the challenges that you have when you're working with most of the parties that are involved with your transaction, whether it's the realtor, the escrow company, the mortgage company, the insurance company, all people have a vested interest in the closing of a deal. They get paid on commission, and so part of the role of the attorney is to really look at this from a legal perspective, even maybe a financial perspective, a personal perspective, to see if this deal makes sense. And having a party that's not vested in closing on your side with a legal acumen really helps you objectively understand where it is that the transaction lies.
Okay, that's within the transaction. Now, ADR?
Alternative dispute resolution.
Okay.
And specifically within that, there's two types of ADR that people get confused with. There's mediation and there's arbitration.
Okay.
So, and arbitration is really just a process of going to court through a private party is really the easiest way to describe that. But mediation is almost mandatory for most real estate transactional issues, at least for residential, depending on what forms you use to purchase it. But you almost have to go through mediation. And it's very, very important to understand that process because even in litigation, about 95% of cases are going to settle. So understanding the way that process works, that process of settling disputes works, is really vital to understanding the process of resolving disputes.
There's been people that we've referred to you in the past, right, where you said, you know what, it's better just give you advice and have you go on your way. Because a lot of times when you get involved with attorneys, things can get pretty expensive on that front. So it's one thing to give someone good advice, which you do a terrific job of, and I would encourage anyone who has any questions to reach out to you online. It's another thing to go into a heavy lawsuit, and then another thing to mediate. Explain the differences between if you really need to go all in with the lawsuit, when you see that is necessary, versus what you can settle in a mediation, which you just said 90%, I believe.
Yeah, so there's really, mediation is usually part and parcel to a lawsuit. It can happen before the litigation is filed, during the litigation, even leading up to the trial. So, but from my perspective, the transactional side is easy because we can really help identify what the cost is going to be up front for doing a deal, depending on how much assistance is needed. And we can become, I guess, what I like to term an anticipated transaction cost. You know, it's kind of the cost of doing business. Litigation's a little more amorphous because nobody budgets for having to have an attorney involved with the process.
Right.
Usually, when you're in that situation, I try and target about $25,000 at issue, is what I'll call it. If there's less than $25,000 at issue, you've got small claims that goes from $0 to $10,000. So you know, there's a forum that's relatively accessible to most people where you can put your disputes before a third party and have them make a decision. It's fast. It gives you an opportunity to have your issues adjudicated and let someone make the call as to what's right and what's wrong and have an enforceable judgment at the end of it. So less than 10 grand, you go there. 10 to 25,000, it's in that amorphous stage because there isn't a remedy available for you. But you know, by the time you start paying attorneys and you start really going into it, you know, your attorney's fees can chew away from your margin very, very quickly.
Right.
And it may make more sense for you to try and resolve it informally. So, you know, there's a judgment call that has to be made there. But at the end of the day, you know, that 10 to 25 thing, there may not be a good remedy available for you in the law that's going to make you whole.
I can't help but be curious on what are the majority of the cases that you do get involved with, right? You know, I bought a house last year, did renovation, and I look at some of these homes in San Diego. A lot of them have been flipped, a lot of them have been renovated, a lot of them need to be. And I would imagine, I mean, I'm thinking of a guy that we referred you a few months ago, went through a situation like that. Is that pretty prevalent, these properties that have been fixed and left What do things
we-
people need to look out for? What's the best advice you can give to somebody who's getting involved in a
One of the
transaction?
major, so there's two major, if there's an issue of title, right? Because title issues are not going to be resolved via a phone call, or you can't really quantify it in less than $25,000. Because if somebody else is on title and there's a cloud on title, then you almost either have to find a way to resolve it amongst yourselves or get a lawyer involved.
Does title insurance kick in there?
It can, depending on the circumstances, but more often
Yeah.
than not, this results in what's called a partition action. Usually two people go in, they have a deal, whether it's on paper or not, the way that the house is going to be treated, and they both go on title. Usually one person wants to live there, one person wants to finance it, or both people live on it, and then there's a dispute. So partition actions where there's two people on title, title insurance wouldn't kick in under those facts because there's a mutual agreement to have both people on title at the beginning. It's just one party decides to go one direction and the other one goes sideways. So,
Okay.
so partition actions, again, for your friend that had called in, we ran up against that $25,000 issue, and he had a disclosure issue, and disclosure is a really common problem. So disclosure issue is one that can actually get people into trouble.
So by essentially disclosure, not saying that there's something wrong with the property. Heck, you have to let people know if someone died in the property. There's a lot of disclosures out there.
It's really a question of whether the disclosure materially affects the value of the property. So, like, for example, we have one case that's going to trial. They disclosed a parking spot. It was a different parking spot. Another case where they disclosed a certain aspect of the property regarding the title, and it was completely false. So it was just these issues come up in the context of disclosure.